Mrs. Turner. I forget her name sometimes. I'm going to give you this mic. What's her name? Latasha McCurry. First, you were the first what? SPLC, I probably don't say it right. First female Southern black lawyer. You are black, we got that part right, yeah. Well, tell folk who you are. You put that on someplace. I don't know how to work.
Good evening, can you all hear me? Good evening. Okay, that's great. So I have about 20 minutes, which is not, if one person asks a question, that's gonna take up all the time, but that's okay. I've been forced to do more with a lot less, so I'm gonna do my best to try to answer. The most important thing is to try to get you the basic information, to try to answer any questions that come up. It may be that some questions have to be answered outside of this setting to get you a full answer. And then to kind of follow in the previous presenters and put in my disclaimers forward, my actual expertise is not in estate planning, although I have drafted plenty of wills and can give you some general information. Some of the more in-depth stuff you want to talk to a professional who that is their expertise, okay? So I want to start by trying to bridge the gap between, I'm going to move this back a little bit because I feel like I can see you but not you. I'm going to try to bridge the gap between where we started with talking about money and the insurance and then bring us to the point of what we're going to talk about today. So after Bishop did his presentation a couple of weeks ago, it left me going home saying, this is a lot of great information if I had gotten this when I was 19. But now that I'm 39, you know, how do I process all of this information in a way that's going to benefit me? Or is this just information that is now past my time? And so I was thinking on that and pondering it, and God reminded me of two things. The first thing was, he reminded me that your latter days shall be greater than your former days, right? Aren't you glad that we serve a God that can make our ending better than our beginning, right? And we don't have to, it doesn't matter where we start at, the God that we serve is able to make our ending even greater than that. So that was the first thing that he reminded me, and that was encouraging. And then the second thing that he reminded me of was that Abraham was an old man when he took Abraham out and showed him the promised land. And what he said to Abraham was, he said, as far as you can see, I'll give to thee. And so what you want to think about is, what you want to know and be reminded of is the fact that God can give you as much or as little as you have vision for. And the question is really, how much of it do you see? And that really goes back to something that Bishop was saying during his presentation, which is that we have to start with the vision. So if you can't see it, then God can perform it, but will God perform it through you if you don't have the vision for it? If we have vision for things, God has the ability to manifest those things through us. And one of the things that God told Abraham after telling him to, as far as you see, I'll give to thee, he said, now go and get up and walk the land. He said, I want you to walk around and walk the length and the breadth of it, get a feel for it, right? And that's encouraging to us because it reminds us that, you know, that we can call things that are not as though they are, right? So maybe our bank account doesn't have anything in it, but we walk in the bank anyhow, expecting something, right? Maybe the car or the house doesn't belong to us, but we drive around the block, you know, every month just in case something happens, right? And so he tells them to walk the land. I want you to walk it. And I take that as a demonstration of Abraham's faith. You know, is Abraham just listening to what God says, but is he going to put something into action by doing the walking out himself? And that really brings us to tonight's lesson, because when we look in Joshua, what we see in chapter 14 is that Joshua has this point in time where he says, he's 85 at this point. And he's saying, Moses said to me that the very land that you walked on is now your inheritance, right? So if we connect what we see with Abraham and connect that to Joshua, we see that the manifestation of our faith in walking out what we believe that God will do, it actually leads us to a point of leaving something of an inheritance for ourselves, but not only an inheritance for ourselves, but also for our children. Because that's what we see in Joshua as well. Joshua talks about the fact that what he has is now not only his inheritance, but it will be something that will be left to his children as well. And that's what we're going to talk about tonight. We're going to talk about inheritance, talking about generally estate planning, which most people think about as wills and trust. And then we just throw estates in there because it's a catch-all. So we'll talk about that tonight, and I'll try to answer what questions you have. And so, you're putting up my... So the first thing that I think that we want to know is we want to know that God has given us encouragement and an okay to leave an inheritance, right? It's not a bad thing. And this was something that Bishop also touched on. When, sometimes we have to overcome the things that we have learned in our past. So I have there a scripture from Proverbs 13:22, which says, a good person leaves an inheritance for their children. We know that God thinks that an inheritance, leaving something for your kids, is a good thing, right? And so I was saying, overcoming the past realities. And so I use this part of a song that most of us know. It says, Papa was a rolling stone. Wherever he laid his head was his home. But when he died, all he left us was alone, right? And so he left us alone by ourselves, but what if he left us an actual loan that we had to keep paying for, right? And so, and that connects us to Shondalin's message, because she gave us all the slips, and we had to open up and see whether or not we were left with debt or whether we were left with something, right? And so one of the ways that we as individuals deal with planning for what our loved ones will encounter, even if we leave them alone, one of the ways that we do that is we plan what will happen afterwards. And that's what estate planning is all about. It's about how do we direct what we have after we are no longer here. And so let's talk about that. So first I just put up some scriptures here on the next slide that, again, validate the fact that God desires for us to leave an inheritance to our children. But as I want to connect the overcoming past realities, I remember talking to an individual one time she was about to give up her home. She had adult children and grandchildren. And I said to her, why would you want to just give up your home? That was basically the only property that she had, only thing that she had. And, you know, we know how important it is to be a homeowner, right? And she said, well, I won't live to see it paid off. And I said, but you have children and you have grandchildren. And she said, well, nobody left anything to me, you know. So she wasn't seeing the importance of leaving something behind. And just because someone didn't leave anything to us doesn't mean that we have to follow in those same footsteps. Maybe we're not able to do that, but if we're able to, then we want to know that it is a good thing to leave something behind. Am I not picking up on the mic? I can. Okay, thank you. Okay. So the next slide is just, I don't know how well you can see it, but it's just several scriptures that talk about the fact that God desires for us to leave an inheritance to our descendants. And the first one says, leaving an inheritance is a common theme throughout the Bible. That's just general information. The first scripture, Exodus 32:13 says, I will make your descendants as numerous as the stars in the sky, and I will give your descendants all this land I promised them, and it will be their inheritance forever. The third one says, I walk in the way of righteousness along the paths of justice, bestowing a rich inheritance on those who love me and making their treasures full. That's in Proverbs chapter 8. So generally there are several ways that you can leave money to your loved ones. We're going to focus primarily on the top two. Wills, trusts, insurance policies, which Shonda already covered, retirement accounts, jointly owned real estate, and pay on death accounts or investments. And that's just like an overview of them. That's not all inclusive. Right? Okay. So let's talk about wills and trusts, right? So this is just kind of a comparison between some of the high points of the difference between a will and a trust. And so I'm just going to talk about them and then take a moment to answer some questions that you have. And so let's just talk about wills first, right? How many of you have heard of a will before? Most of us. Most of us kind of have a general idea of what a will is, right? And so a will is a document that provides a way in which a person can distribute their property when they die. And so what a will is written, so it's on a piece of paper. It can be handwritten. In the state of Alabama, there has to be two people who witness it, and you're also going to have a notary. So if it's something that you did in your home, or if someone did it in a nursing home, there would have to be two witnesses that were there, and it would also have to be done in front of a notary. The notary will be the third person. They wouldn't be the signing witness. So it has to be something that is written down. A will is going to be effective until you either replace it with another will, or it's effective as long as it's done properly, right? So once you draft a will, unless you draft a new one, then the first one that you put into effect properly is going to be your existing will. So it can be updated. Most wills have a catch-all clause in it. So, for example, if you did a will now and 10 years from now you acquire more property, that it would be included in that will through the catch-all. So where it would make a difference is if you had distributions to certain, you wanted it to be distributed in a certain way that wasn't reflected in your will, okay? That's where you would want to update it. Otherwise, everything is going to get caught up in that catch-all clause of the will, okay? A will has to be probated in order to be effective, and that's after the person passes, right? So if a person if you draft a will, you want your loved ones to know where it's at. So you don't want to have it hidden somewhere and nobody knows where it's at. Everybody's searching through the house for it and no one can find it, or no one even knows that it exists. Another thing that you want to do is, as part of a will, you're going to name a personal representative. And so generally, a personal representative can be anyone that you designate it to be. So it can be someone in your family. It can be a friend that you trust. Sometimes it's the person's attorney or the person who drafted the will on their behalf. But one of the things that you don't want to do that will invalidate your will is if the person who drafts your will is in your will, then it's likely going to be challenged because there's a conflict of interest there. So just in case y'all wanted to put Tasha in your will, you wouldn't want me to draft that will because then your loved ones would challenge it and say Tasha did that because she was trying to keep all the money for herself, right? So for those of you who may have relatives who are attorneys or who may have the ability to draft a will on your behalf, you just want to keep that in mind because that's often something that will be challenged. Another thing that's big in Alabama is that just in case you have somebody that you want to cut out of your will, if you have a spouse in Alabama, you cannot cut your spouse out of the will, right? So that's something that you want to know. And no matter how you slice it, the state law doesn't allow you to do that. In fact, your living spouse takes most of your stuff right off the top, right? So so what you do is you put them in the will, but you put them like this much in the will. But so you can't write your spouse out of the will. The other thing is there is an exemption for small estates. So if an estate, the value of the estate is less than $25,000 or less, it can go past probate. So if you own a home, most of you are going to fall outside of that exemption because your home is likely going to exceed that value. But if you have a loved one, or if that loved one if they're leaving, and this also exempt are like household goods, so they're not talking about the value of your couch or your television or things like that. But if, for example, a vehicle there would be value to that vehicle that would be counted. So if a person has, let's say they have several vehicles and they have some other things, and those things come up under the value of $25,000, under Alabama law, that will be exempt. And so that is some important information that you might want to share with me. Because it's probated, it's public information, and so I could tell from some of the things that have been said before there, some people may have fear of the process of probating a will, but if it worked in a perfect world, the way that probate is a way to be able to protect your assets from being distributed in a way that you didn't intend. So it's public record so that people can challenge it. If somebody's named in the will, but let's say Tasha didn't tell them about that, then it's a public record so they can go search for it themselves and see if they are part of your, if they are a recipient or named in the will, and that they receive something from the will. So it makes it so that everybody knows what's happening. Now, most of us aren't down at the probate court just looking and see, you know, what somebody left. So don't think of it as public, like, oh, everybody's going to know my business. Nobody's looking unless they're specifically looking. But it is searchable so that people can know what was done and how it was done. And so really it's about transparency. There are, of course, estate taxes that go along with probating your will. And I think Pastor mentioned previously some of the fees that come along with that. So if there's a person who is the personal representative or the administrator of your will, depending on who that person is, for example, if there is an attorney who's doing that, there may be a fee that's attached to that administration of the will. If it's a family member, that family member the probate may not have ordered that they receive a fee, but they may, depending on how big the estate is and what needs to be done. The personal representative, when I say administer, that's the person who is responsible for ensuring that what you say in the will is being done. So if you want to leave some money to your children or your home, they're responsible for making sure that gets executed. If you're named as a representative in the will, you have the right to say you don't want to do that. And so what a good thing to do is to name two people as a representative, your primary and your alternative, okay? If you don't have a will and you don't have a trust, which we'll talk about next, then you die what they call intestate. That means the law decides what happens with your property if it's not exempt, right? So they decide the order in which that goes. And in Alabama, if you have a living spouse, first it's going there. There are some variations to how it happens, but the first $100,000 goes to that spouse, right? And then if there's children, and that's if there are no parents or children living. If there are children living that you all share together, then the first $50,000 would go to the spouse, and then the remainder would be divided among your children. If you don't share children together, but you have living children, then half of it goes to your living spouse, half of it goes to your living children. If there is no living spouse, it starts with the children, goes to your parents, goes to your siblings, then goes to grandparents, etc., right? But the state has already decided how it will be administered if you don't decide. So what do we want to do? We want to make our own decisions about it, right? I want to stop right there and see if anyone has any general questions about wills. Okay. Oh.
They did talk to her about doing a will and so forth, and her thought process was, I only have two children. Everything I have goes to my children.
Yes.
And it has not been a simple process. Even with her car, my cousin took it to California, but he's not even able to get it put in his name, get it registered because of whatever reason.
Yes.
But I think a lot of times we think that way. If I only have children, then everything I have will just go to my children.
Yes.
But it's not always that simple.
Yeah, no, I think that's a very great point, because if there's anything legal that needs to be transferred, such as titles, if you own a home, if the deed needs to be transferred, then they're going to be looking for the paperwork, the probated paperwork, to ensure that you are the proper person who is who is entitled to this property. And so it isn't as simple as it just goes here. It can go there, but then do they have legal entitlement to it so that they can actually use it in a way that's meaningful?
Say you have a significant other that used to be significant, but is no longer significant.
Or are you still married? Still married.
Yes.
Okay. I just want all the facts. That's it.
But they haven't been together for 15, 20 years. Would that, would she be able to take away from the grandkids or the children?
The law says yes. As long as you're legally married, you can be separated, you can have not seen each other in 50 years. If you're legally married and she or he goes down and says, this is my husband or wife, I want my money, yes. We have a question.
Yes. My question is, you stated that you can have two on the will. Can you have more than two beneficiaries?
Yes, so you can, I was saying for the person who administers the estate, you would want to name two people. That's my personal opinion and suggestion. But you can have as many beneficiaries as you want.
I have another question. What if you have a spouse and you have no children? What if the both of you die?
So in your will, you have the ability to name it to whoever you want. Now, if you died without a will, what would happen? It would then go to other people in your family, starting with, if you had living parents. If not, then it would probably trickle down to your nieces and nephews if you had that. But if you have a will, you can direct it to go to your best friend if you wanted to. You can direct it to go to a charity if you want to. Anywhere that you want it to go, you have the ability to be able to do that. So that's the nice thing about a will too, is that you can tell your money, your property, where you want it to go.
In fact, that's what we're having in class. I encounter so many situations where people don't have wills, and it's just hard. It's hard to get it straightened out after you're gone. And so we need to start doing this because we're also losing a lot of property from our community because it stays in the state. Nobody want to pay taxes because they don't know who's going to get it. The whole 9 yards. So they're fighting because I paid taxes for 5 years and I got it. So you need to get this done so you won't have all that bad family reunion, Bishop.
And then I think the other thing that's important too, pastors, if you think about what your family will be dealing with, they're trying to bury you, and then they're dealing with a lot of the emotions that come along and the grief that comes along with that. This is like taking one more thing off the table that they have to deal with in that moment.
What I had found out dealing with my daddy's estate, with the cars and stuff, when I went up to the Lee County Courthouse, they said what they see, even before someone been dead 12 hours, a brother or sister to run up there with the title, and once that brother or sister check, they say X, but that's what I found out dealing with daddy's estate.
And I think that probably is true in the sense that people do that, but the law allows the administrator of the state to be able to go after any property that was misused or abused. And I've seen people go into court because
What happens to the house when is it the oldest, the youngest? How does that work?
You're saying if it's done in a will? Okay, so if it's done, you're saying all the kids equally. So that means you each own 1/3 of it. So you either need to come together or buy each other out. And in a situation like that too, anyone who, and this is true whether this is true if any of you are named on somebody else's property or named on property together, anybody that is named on that deed can live in that home whether they're welcome there or not. So if you're living there and they move in and they have legal interest to it, you can't do anything about it.
I don't know if you answered this already, but tell me this. Does wills take precedence over financial liabilities? Because when my grandmother passed, she still had financial liabilities, a loan she owed, but she didn't have a will. So therefore, they came back for their money and they had to get it first before family was paid out.
Yes, so a will is your liabilities are still going, those liabilities which survive death are still going, a creditor has a period of time where they can try to get whatever money that goes through your estate. That's why everything is supposed to be funneled together so it can deal with your liabilities and also whatever remaining assets you have. But there is a period of time in which those claims have to be made. That's all.
I have a family member who was told by an attorney that the will did not have to be probated. I'm not understanding that well. We may have to talk later though,
Okay.
for real. But what is the advantage, I guess the disadvantage probably more of the will not being probated? I guess that's what.
So if it's not probated within 5 years, by the way, of the time that the person dies, then it's not effective. So what's in the will is meaningless unless it's probated. It's only legally effective at the time that it's probated, unless it falls in that $25,000 estate exemption. So that may be the reason why I don't know. We can talk about it. But if it fell within an exemption, that might be the reason why the attorney says that it didn't need to be probated. But otherwise, in order to be legally effective, then it has to be probated in the state of Alabama. Okay. So when you go into the courthouse, there's a part of the courthouse that says probate court. And it is where you will, anytime, they keep property records mostly. So if you own a home, your deed is filed somewhere in that probate area. But probate court also deals with, they deal with guardianship issues. They deal with issues such as if a person is, you have a loved one who has special needs and you want to have that person committed, they deal with that. But then they also deal with wills and estates, as well as power of attorneys are all filed in that court. And so just like if you were thinking about like a divorce court or it's just a specialty court, and they deal with those types of things. So they do all court, well, in Alabama, you can Google your probate court and they will tell you a list of what services they provide. A probate court in Alabama also deals with, like, if you are, you have a business entity that you want to file articles of incorporation, they deal with those as well. So they'll tell you fees associated with that. You can often search property records, deeds, wills. Those things can be searched online these days, so long as you have a certain amount of information. If you call, they will answer basic questions, mostly that deals with processes. They're not going to give you any legal advice, and they'll tell you that up front. But usually they're very helpful. If you need a particular form or something of that sort, then they'll direct you to what you need.
So if you and your husband are on all the same accounts, you know, you're joint on the deed and cars, blah, 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 is a will still advisable to have?
It is. Okay. It is, because one of the, in the example of what if a sudden death of both, or there is a time period, actually, like your surviving spouse is only legally a surviving spouse if they survive you for so much time. And so in that instance, then you don't have any coverage of what happens. And I'm going to say this, and then, do you want one? Okay. But the other thing is, and we'll get to some free resources. I have a slide for that, free resources within our areas. Because one, people always ask, can I just go online and Google this? And in the time of Google, everybody's an expert on everything. That's not advisable. You can do that, but we have free resources in our county where lawyers, like, this makes us feel good to do this kind of stuff. Lawyers will do this for free for you if you go through the proper channels and you're not. Now, if you're a billionaire and you come in and you want to get a free will, that's probably not going to happen. But for most of us, there are resources that can be provided. So I advise you not to use the online. If you're, a lot of your companies may provide services that you can do. In the military, they provide services. So see what is available to you before you decide to pull one of those forms offline. Okay. Here and then. more than one wife? Insurance policy. So insurance policies are they can be included in your will, but they don't automatically go. Like, so insurance policy, the benefits are going to go to your beneficiary that you named as part of the policy. So if you did not name your legal spouse that you're separated from as a beneficiary, then they don't touch that money. Unless in your will, you include in your will the insurance policy, then yes. Okay. Yeah. I'm glad to help you out on that. Yes, ma'am. That probably wasn't because he didn't leave it in the will. It probably was because he still owed money on it. But so she is saying now that the lawyer said, well, if you have to pay the balance of the car, or you turn the car back in, and you have to purchase another car. Yeah, that sounds right. Yes, yes. Okay. Do you have any? We have a question.
So it's really not a question, it's more of a comment, because I went through something too. Okay. If you got a will and then you got an insurance policy and you get divorced, you sort of better go make sure you change the recipient of the beneficiary on the will, because if you forget, when you die, it's going, like you said earlier, it's going to go to that person no matter how much you fuss. Yeah. And turn over in your grave. So that's that is true, and that's true for anything where you have beneficiaries named. But in a will, let's assume in a will you don't name a spouse at all, whether you're married or divorced. If they're named in the will, you want to have that will changed. If they're not named in the will, once they're not your legal spouse anymore, they don't have any entitlement. But your insurance policies, if they are the named beneficiary, it still goes to them. And often people don't think about changing those things, but that's something that you do want to change. Yes, ma'am.
I had a lady that worked with me, and her husband passed, and just his name was on the house. So when he passed, the people for the house wanted her to move out, or she had to refinance it in her name. And she was almost about to lose the house. So, and I didn't know that at the time, and I was like, I was trying to help her, but I didn't know that. I thought it would automatically be hers, but yeah. So it's kind of there's two different things that's happening here. One is there is a mortgage that's attached to it. So if that property did not have a mortgage to it, then the deed, you're just talking about a legal interest through a deed, will automatically, that would go fully into that person's estate, and then she would have a right to it. The mortgage company has the ability, and all that fine print, they have the ability to deny any person that would take over that mortgage. They have the ability to make that person refinance, and that has to do with the mortgage and not with any estate laws. Okay. So while we're switching over, I'm going to try to touch on trust a little bit so we can talk about the difference between trust are something that we kind of generally, most of us have thought about traditionally. This is when you have legacy money, as they were referring.
What's legacy money?
So we have
We've often thought about trust as being something that when you have a lot of money, but it's not. You can have a trust no matter how much money you have if you want to. And so trust is just another way to be able to direct your money. And the primary thing to know, there are lots of things. This is where you really need to have somebody who's a professional to talk to about this. So, because there are different trusts that you can have, and there are different benefits and detriments to each one. And so a trust is a fiduciary arrangement where someone is essentially the trustee over your property, your belongings, and then they have the administration over that. So a trust can be what they call revocable or irrevocable. A revocable means that you have the ability to be able to change it over time. So once you can use the money or the assets that are in your trust while you're still living, you have the ability to manage it and change it while you're living. At the point that you die, wherever it's at then, that's where it stays at. Irrevocable, and that's called a living trust. And a living trust does not do away with estate taxes. So if you're thinking having a living trust is going to keep you from paying estate taxes, it won't. You'll still pay estate taxes the same way if you probate it. The difference and the benefit that it has is instead of the 6 to 7 months that your family might wait to receive your benefits through probate, if you had a will, that it could be done a lot more quickly. So your family could have access to those benefits more quickly than if you had a probated will, but it's still subject to taxes. An irrevocable trust, on the other hand, is once it's done, it's done. You can't change it. So in the example of, you put your then spouse into that irrevocable trust, and then you no longer wanted them in there because you got divorced, they're in that irrevocable trust because you can't change it. And it does bypass some estate taxes. And so the reason why it's able to do that in part is because you're not able to continue to manage those funds and you don't have access to it. So I'm not a tax attorney. You want to talk to a tax attorney about the specifics of it, how much percentages and those things, but those are the basic differences between those two. And then, like I said, it allows you to control your wealth while you're still living. And then it's not a public record, so no one can go and do a public search and figure out what you left behind. It's not public. Okay. Any questions about trust?
One.
Okay.
So if I ran a business and I had other properties, and my properties was in a trust, and the business got in trouble or a lawsuit, would the properties in the trust be in jeopardy based upon a lawsuit of a business that I own?
If it's in an irrevocable trust, then probably not, because that is If it's in a revocable trust, then yes, because those are assets that you still technically have while you're alive. Okay. No questions? Nobody wants trust. Okay. I just threw this in here because Pastor said, I didn't just throw it in here, but I put this in here because Pastor said there might be questions on long-term home care. So when we say estate planning, the key word is planning. And this is true for all of it. We want to think about these things in advance. We don't want to wait until tragedy hits and then be trying to figure this stuff out at the last minute. And this is particularly true when it comes to long-term home care, which is, it could be nursing home care, it could be having an individual, a loved one in your home that you're taking care of. Then you want to do that planning in advance. And so it can be, nursing homes are very expensive. I think one of the, you can't really see, I put too much on one slide, but it says between ages 65 and 69, the likelihood of you spending some time in the nursing home care is about 10%. At age 75 to 80, that goes up to 30%, and after age 80, 45% of people spend time in long-term care. And the people who are in the 80 and above category, the general estimated time is about 2.5 to 3 years that they would spend in long-term care. It's much shorter, about a year for the ages that are earlier than that. But the average, this was in 2009, this is 10 years ago, that average amount of money was $55,000 per year for a person to be in there. So you can see how quickly that amount escalates. And that also can give you some insight into why people are trying to qualify for Medicare or Medicaid in order to be able to pay for that, because it depletes your assets very quickly. And so what does Medicare cover? Very little and often nothing. Medicare is going to cover mostly your short term. If you've been hospitalized for 3 days and then you are ordered to be able to go into long-term care, they're going to pay for a certain amount of that for just a short period of time. And then after that, it's in 2009 again, these are old statistics, $133.50 per day for a person to stay in there. Unless you have some gap coverage, which most of our Blue Cross Blue Shield policies don't have. So if you're looking for that gap coverage, you want to talk to your insurance company to make sure you have it. What you see most people trying to use is Medicaid, and Medicaid will do some coverage, but that's when you come into the restrictions. You basically have to exhaust your resources. You can't have more than $2,000 a month of income coming in. There are some exceptions as it relates to if you have a living spouse that's living in the home. There are some exceptions that exist there, but there are some limited ways around that. But if you see, you can't see it, but 3 years before, you want to have started planning for this and allocating your resources 3 years in advance of when you think someone. So if you have a loved one who you think maybe even 10 years from now, maybe going into long-term care, you want to start planning for that in advance. You don't want to wait until they need to go into long-term care.
So are you saying then if I own this property and when I turn 42 next year, that it'll be too late to change it then? So okay, my property's in a trust at that time. Is it still my property?
If it's in an irrevocable trust, no. If it's in a living trust, then yes.
They're just trying to get my property.
So, but yeah, so you want to have, what they're going to be looking for is any stuff that you try to get rid of below market value very quickly. That's what they're looking for, because they know people are trying to get rid of their assets so that they can qualify. And so if you sell your home for $2.50, then that's going to be a huge red flag that it wasn't sold for market value and that you were doing it to be able to get rid of your, I mean, it's basically considered fraud.
So if you know, you got a loved one that's about to, that you think they have to make go into long-term care, is it best to purchase the property from that loved one and, you know, and have the resources that way?
I'm not going to say best, but I think that would be a good idea. With, I think, a 3-year period. And they're going to be looking at a 3-year period. Yes. Well, yes. I'm going to get her and then I'm going to come back to you. Okay. Yeah, no, I think the mom was being very smart. I mean, all of this is going to be, you're going to have to think about your own personal circumstances, because if you have someone that you don't trust how they're going to deal with that property, which most of us have some reservations in general about other people managing our stuff, then that's going to be a concern that you have, and that you're going to want to try to think through how to be able to deal with that. But the idea in a perfect world is that if you're going to be allocating this property to someone anyhow, then you can start making those early decisions about how you want to be able to do that. Right. The other thing that I didn't cover on wills is that a person needs to be of sound mind and not under undue influence when they make their will out. So if a person is barely, they're almost incapacitated, and you take it up there and guide their hand to the signature, that's not valid. Okay. So then, okay. Oh, I'm so sorry.
So if you say that a person is not married, got like 7 kids, owns businesses, houses, everything,
yes,
does not have a will or anything like that. So where does his stuff go? And everything is like paid for. So does it go down to his kids?
Well, it's going to start with the kids, assuming there is no spouse.
So does it go from the oldest child, or everything just get equal out to all of the kids?
It will be divided equally among all of your children, all of your living children. Yes. So it's going to be divided by 1/7 for each child.
Does it really have to be on the birth certificate? Do they have to be? Does the parent have to be on the birth certificate?
That's not what makes somebody a legal parent. So no, there could be other ways that you could. A child that you adopt, for example, would be, and another, that would be your legal child.
So it'll go to his legal kids, but if he claimed other two, that he's been.
Yeah. Well, the thing is that more than likely, I mean, if somebody challenges it, then there's going to have to be proof of who's who.
I was just wondering if their mama is still living, but.
No, I think that's a very good question. And I also, one of the things that you want to, for those of, you have some examples of where people are living. As a grandparent, you might be getting military benefits, so you adopt your grandchild even though that parent is still taking care of it for purposes of trying to get them under your coverage. Once that child is adopted to you, that's your child. So that if you die intestate, meaning without a will, then that child falls into your estate and not into that parent's estate. They're no longer that parent's child. So even though you're still taking care of them, they're not yours when it comes time for that biological parent to pass. So that's another thing that might be important.
I think my voice carries very well.
You're doing it for the camera.
Okay. If you have children, so like there are 4 or 5 children, and then their brothers and sisters,
yes,
and they want to come in and try to, do they have a say so with that?
No. If there are living children, and there are no living spouses, and this is all if you die without a will. In the state of Alabama, everything goes equally to those living children. If there are no living children, then it would go to parents, siblings. So if they have siblings, that means nobody can be in line in front of them. If you have somebody in front of you, it goes to the person in front, and then it passes through that person's estate. Okay. Yes.
I have one issue with when you're dividing stuff up between multiple people. I just happen to be the baby child of 3, and so when my grandfather died and left the land, it went to all 3 of us, but I guess there's a Latin term that they put on deeds that just says "and others" or whatever. Yeah. So my older sister died, my middle sister's, close, and so I'm paying the taxes, and I look at it and it just says "and other." So my name really isn't on it. It's just the way that it's written. So when you divide stuff up, you just got to pay attention to the writing of the deed.
And that's where the probate comes in, because probate establishes who it legally belongs to. But there's something else in my mind that's important to what you just said, which is that if it's divided equally among the children, let's say you and your other two siblings, their third of the estate doesn't automatically come to you when they pass away. It goes to their children and their descendants. And so that's where it kind of gets complicated, because it can go from 3 people owning it to then you and then your nieces and nephews owning it. And it could be 20 of you all before it gets done with. And you can't sell it or do anything without everybody being on the same page. So if you, and let me just say this, so if you have multiple things that you can give away, you might consider giving one to one child, one to another child, instead of letting it be divided equally, because then, you know, they can fight about what they got, but nobody can do any, you won't have any problems, legal problems there.
So personal experience, my mother died, there was 10 of us, so there was 9 left. So in her deed, she put down that the house would be divided equally and sold at a set price. So we bought all out, 4 of us bought the rest out, so it was 4 left. Then one of the brothers died about a year ago, and in the deed it said that it would go to the, well, it was deeded to the 4. But the lesson I learned, and I got it corrected, was you got to make sure the deed says is whatever shares are left goes to the surviving of the living.
Yes.
If it doesn't, then it becomes heirs' property, and that's when it gets messy.
Yes, that's one way to be able to fix that, is to, the surviving issue is the term that they use. Okay. No, we're at the end.
I just have one question.
Yes, sir.
Because my father didn't have a will, neither did my mother. But as the oldest child, I had to take care of everything. With my father, they keep sending me his mortgage bills, even though I try to take care of everything. I sent death certificates to everybody. I was not on his mortgage. I was not on anything that he owned as far as my name.
Yes.
Also with the power of attorney, I wanted people to know that that's only good while the person is living.
That's right.
And so even though the power of attorney gave me, I was over everything, when he died, now the mortgage company continues to send me things. I guess there have been squatters in the home. The police department called me one night saying that they had my name on record. So they keep trying to get the balance of this house from me. Do I have a legal responsibility to the mortgage?
Depends, are you trying to keep the property?
Oh, no. I sent them a death certificate with all of the other debtors at the time of his death. I do have a copy of his mortgage and everything that he did. I'm not on there. It's just his name.
Yeah. So I think what is likely happening is that you are the legal owner of the property, because even though he didn't pass with a will, you were the surviving child that it went to. And so legally, you own the property by deed, and then the mortgage company still has a mortgage on it. So since you're the owner, they're trying to collect that from you. If you don't pay it, then they have the right to foreclose on it, and then they can get their money that way. So if you're not trying to actively keep the property, then you may just allow them to foreclose. Yeah.
There was a lawyer that contacted me, and I had my other siblings sign that said that they don't have the $80,000.
Yes.
They don't want the property.
Yeah.
Neither do I. We returned that. We did that process. And so now I feel like I'm being harassed.
Yeah.
It's 4 years.
Yeah.
You said they send me them, they send me past due notices, and it's frustrating.
Yes.
I told them I don't want
So, no, it's going to foreclose, and the mortgage is going to foreclose on the mortgagee, which is the person who's deceased. Yes. But the legal interest, whatever's left, will remain the legal interest. But you're right. You could, as the owner, sell that property, satisfy that deed, and then whatever's remaining, the mortgage company may be after you 4 years later because the property's not worth the $80,000 that they want. That's right.
They're going to still come after that. Try to come after that. Remaining.
Okay. Okay. So let me just make some closing remarks because we're out of time. Thank you all for the questions. I hope this has been helpful. We have. Yeah, I'm going to tell you. Yes, I am. The Madison County Volunteer Lawyers Program, they do free clinics throughout the year. One of them is the Probate Project. It specifically deals with wills and estates. These are free services that we have within our county. The number is 256-539-2278. You can also just Google Madison County Volunteer Lawyers Program. They do many things in terms of any legal help that you might need. So if you're interested in other legal services, it is not Legal Services of Alabama. That's a different entity. These are lawyers who volunteer. So if you make more money than what you would qualify to get legal service help, then you can often go to Madison County Volunteer Lawyers Program. There's still an income attached to it, but it's a much higher income than what you would need in legal services. So they also do Wills for Heroes, which any of you who are first responders might be familiar with. But they provide those services to first responders for free as well. So if you're a firefighter, police person, okay. So then legal services is also, one thing that you may look for, I put also the University of Alabama's Elder Law Clinic. We have other law schools in the state of Alabama that you may Google. Most of law schools provide free clinics. Elder Law is a very popular one. They provide all types of services to people who are elderly, and they may their ages may depend, change depending on what entity. But they provide things dealing with nursing homes, Social Security. If you fall into those categories, you can contact one of the free elder law clinics for that. But legal services also provides elder law services. And so if you Google Legal Services of Alabama, they have locations for all of the state locations there. If you're in Huntsville, Huntsville covers several of the surrounding counties, then you can just call the one in Huntsville, okay? And that's it. I was going to say about power of attorney. Someone touched on it already. Power of attorney is only effective while you are living. At the time of your death, the person who is the power of attorney no longer has power over. Your will takes precedent at that point. Thank you all for your time and attention. There are a couple of handouts at the front. I think we printed like maybe 20. So if you really want to get some information that you want to take home with you, then there's about 20 handouts at the front.
All right. That was good. Okay, Mary, hand these out. Now we are proposing for our seniors at least. Clinic one day, bringing in professionals to help you prepare wills and powers of attorney on the spot. So we haven't gotten that team together yet, but we'll let you know when that day comes. So there'll be a short on those of you who want to explore wills or don't have a will and you want a will. We're going to try to get some volunteers, one of these groups that she mentioned, to come in and at that point prepare you, get you straight on the will. As pastor, I run into situations that are heartbreaking as it relates to property and wills, and I've seen families just, they just fight. They just fight. When it comes down to money, things get strange. In fact, I see them change like Dr. Jekyll's and Mr. Hyde's, and it's heart-wrenching. And I don't know any other community but mine, but it's sad because I see at the end of the funeral sisters and brothers who won't talk to each other to the next funerals, and sometimes they won't even come to the next funeral because someone then